Welcome to TCPA Audit. The narrator of this video is not an attorney, and nothing in this video is legal advice. This video only contains the musings and thoughts of a non-lawyer. The purpose of this video is for entertainment and to provoke thought. You should not assume anything you hear in this video is true. The narrator of this video's thoughts and opinions might well be wrong. If you find anything interesting in this video, you should research it yourself. In case you missed it the first time, the narrator of this video is not an attorney, and nothing in this video is legal advice. Please don't ask the narrator of the video for legal advice or to answer legal questions. Only lawyers can give legal advice, and the narrator is not a lawyer and can't comment on your situation. If you would like the narrator to comment on telemarketing-related public information, such as a court opinion, please email tcpaudit@proton.me with a link to the public record, and why you think that public record merits a closer look.
Hello, this is part 2 of a 3-part series looking at some lawsuits by Ken Johansen. And in the first case, we looked at how he made some choices that the court didn't like at all. In this lawsuit, he again makes some choices that the court doesn't like at all, and it kind of builds on mistakes that the court identified in his first lawsuit, and let's go through and talk about that. This is an order denying plaintiff's motion for class certification. I'm not an expert or even particularly knowledgeable at all on class action lawsuits, but it's my understanding that for one plaintiff to represent a class of people, you would file this motion and the court would have to grant it. And the court signals right up front that this motion is going to be denied. Background: Ken Johansen sues a Bluegreen Vacations Unlimited for violations of the Telephone Consumer Protection Act. And in my experience, when a court ruling kind of puts a plaintiff's history of lawsuits right up front, to me that indicates a bias against that plaintiff. Right or wrong, I think that's a pretty clear signal. Plaintiff appears to have an extensive history of filing lawsuits alleging violations of the TCPA, estimating that prior to 2020, plaintiff had filed 60 lawsuits, and estimating since 2014, plaintiff had made an average of $60,000 per year. I don't know how that's relevant, so I think the court is just bringing this up to try to make him look bad and prejudice him. Plaintiff admits it's his typical practice to pose as a consumer when receiving an illegal telemarketing call. Well, what does the court expect him to do? I don't know why the court's bringing that up. According to the second amended complaint, Schumer, on defendant's behalf, placed at least 9 telemarketing calls to plaintiff. Plaintiff received the first telemarketing call on May 26, 2020. This will become very relevant later, so I'm just pointing it out. Plaintiff answers the phone, said hello, but they don't talk. And then the next day he receives a second call. Plaintiff claims he listened to and engaged with a telemarketing representative, intending to conclusively identify the entity responsible for illegally contacting him. Okay, so far so good. During the May 27th call, the representative began the conversation by telling plaintiff she was calling on behalf of the defendant about a vacation package that the plaintiff had previously purchased. Plaintiff continued the conversation and proceeded to pose as defendant's customer. Plaintiff actively engaged with the telemarketing representative for approximately 30 minutes, verifying his personal information, requesting additional information, and knowingly verifying false contact information. Well, it seems in the beginning of the call that the telemarketer said who they were. I don't have enough information so far to say that a 30-minute phone conversation was unreasonable for Mr. Johansen. What if he sues just based on the verbal representation that they're calling from Bluegreen, and then in court, Bluegreen says, well, you know, there's a lot of people that pretend to be us running different scams. we don't know anything about this phone call, we didn't call you. So I don't know, but what if Johansen talked to him for 30 minutes to get them to send him an email, or to get them to mail him something he could take to court and say, no, it really was you, if Bluegreen tries to deny they placed the calls. So far, I don't know that he's done anything unusual. Plaintiff admits that he confirmed the false contact information that the representative had on file, so the representative would prolong and continue the call. Well, I'm fairly certain that if Johansen had told them, I don't know who you are, I don't know why you're calling me, I've never done business with you, I don't want these phone calls, I'm fairly sure that Bluegreen would have just hung up on him. And then, if his intent was to get an email or a postcard or something, well, he wouldn't have that, and that would help Bluegreen later if they wanted to say that they didn't make the calls. Plaintiff admits it's his typical practice to confirm whatever information the telemarketer has on him. Well, I don't know how that's here nor there. Then plaintiff claims that after this second phone call, he received an additional 7 telemarketing calls initiated on behalf of the defendant. Well, I think this is the first place where he could have done something different, and he probably, or he might have, gotten different results from the court. I think after the second phone call, he could have sent an email, or at the end of the phone call, he could have told the telemarketing person, hey, I'm not your customer, I don't know why you're calling me, I just wanted to know who you are, I'm not interested in your services actually, please put me on your do not call list. I think if he had done that, that would have greatly limited the court's ability to come after him like the court does in this opinion, or else it would have been pretty obvious, if the court had continued coming after him, I think it would have been obvious to an appeals court that this district court was abusing their discretion. During this June 2nd, 2020 call, the representative began the conversation by telling the plaintiff she was calling on behalf of the defendant about a vacation package that the plaintiff had previously purchased. So the call goes on. This is, I think, where Johansen makes mistake number 2. Requesting additional information about vacation destinations, adding his spouse, and knowingly verifying false contact information. Well, in the second call, you knew who they were. Now, maybe you're fishing for an email or something in the mail that you didn't get after the first phone call. I could kind of get that if that was his argument. But he adds a spouse to the account. What's the point of that? That's only going to make you look bad later. It's going to drag in other people. What if his spouse starts getting phone calls? To me, that's a second mistake in this lawsuit. Plaintiff readily admits that his conduct during the telephone conversations was deceptive. Plaintiff intentionally prolonged and continued the telephone call by posing as defendant's customer. Well, I think a third mistake that Johansen makes in this lawsuit is he lets the narrative become about deceptive behavior, and that he believes that deceptive behavior is acceptable. Well, he's kind of an undercover investigator on these phone calls. The recipients of telemarketing conversations are typically not going to get very far if you start out with, I don't want your call. Anything you say, I'm going to use to hold you accountable in court. Well, a telemarketer's just going to hang up. That's not going to work. And you don't see a lot of government investigators or police officers who go into an investigation where they know if they identify themselves and what they're after, everyone's just going to scatter. You don't see a lot of those people tell them who they are and why they're there up front, right? That's why it's called undercover investigator. However, let's say that the government does an undercover investigation on you, drags you into court, And are you going to get away with saying, well, but we can't believe what this officer says because he was deceptive? Well, no, the court's never going to let you and I get away with getting out of some undercover investigation because the government investigator was deceptive about who he was. So, in my opinion, the court is going to show extreme bias by pursuing this line of reasoning, but at the same time, Johansen seems to just go along with that narrative and doesn't counter that narrative, and so he kind of lets the court get away with it. So again, I don't know much about class action lawsuits, but it seems like there's 4 prongs to a class certification, and so they're going to talk about typicality. The class representative must possess the same interest and suffer the same injury as the class members in order to be typical under Rule 23A3. And the court's going to go on and say, plaintiff's claim differs from those of the putative class members' claims. The record clearly demonstrates the deceptive and dishonest tactics employed by the plaintiff to establish his claim. Well, again, how many prostitution stings are there where the police officer pretends to be a John and then arrests the prostitute? How many prostitutes have gone into court and said, but he said he was a John, Your Honor, he was deceptive, we can't believe anything he says? Well, this court would never accept that, right? But the court uses it against the citizens here, and I think that's very abusive. But plaintiff Johansen lets the court control the narrative. I never see in this opinion where Johansen pushes back and says, from the get-go, I'm investigating. That's what I have to do to find out who these telemarketers are. And you'll see, in my opinion, the court continued to abuse their discretion. In the order denying defendant's motion to dismiss, this court ruled that the plaintiff had sufficiently alleged that he suffered an injury in fact after having received 2 unwanted phone calls. The first on May 26th, which we remember, he answered, but there was no one there, so no conversation. And the second on May 27th, 2020. The court limited its ruling on injury in fact to the first 2 phone calls, because in part the plaintiff represented in his first amended complaint that he only sought to claim based on the first 2 phone calls. And we saw in part 1, the court took Johansen to task, saying that under 227 of the TCPA, you have to have 2 unwanted phone calls in a 12-month period. Well, he appears to have that in this complaint. But then it seems to me that the judge is going to abuse its discretion by saying, well, I don't really like how you talked to them in the second phone call, so I'm going to retroactively decide that somehow they knew that you were going to behave like this in the second phone call before they even placed it. Therefore, the second phone call is somehow legit. I don't understand how this time machine logic works. How you behaved on the second phone call dictates whether the second phone call was unwanted. How does that work? I don't get it. But another mistake that, in my opinion, Johansen made in this lawsuit was he went after them for the 7 remaining calls, not just the first 2. And if he had gone after him for the 7 phone calls and he'd made a do not recall request in the second phone call, well, what could the court say then, right? Or if he had sent him an email or something after the second call saying, hey, I don't want any more phone calls from you, please put me on your do not call list, what could the court say then? But he didn't do that, and so that kind of opened the door to the court spanking him here. And when a judge is against you, and you don't always know, going in, if the court's going to be against you, you have to kind of put them in a box. don't let the court just do whatever they want to do. Give the court facts that if the court does something like this, the court looks really unreasonable. But Johansen hands the court a set of facts and allows a narrative. The court uses that against him, and what can Johansen do, because he gave him a bad set of facts for himself. So the court must still decide whether the injury alleged caused by each phone call is fairly traceable by the unlawful action of the defendant. Well, doesn't 227 say that it's the initiation of the phone call? It's not what happens later. It's the initiation of an unwanted phone call that encourages the purchase of goods or services. Isn't that what 227C says? Isn't that what we learned in part 1? So how is his conduct on the second unwanted phone call going to ratify that somehow the phone call is suddenly wanted or something? I just don't get the court's logic here at all. If Johansen had done what he should have done in this lawsuit better, if the court had still ruled like this, in my opinion, the court would be ripe for an appeal. But with what Johansen has done, I don't know about appealing this case. Adequacy is another prong in certifying a class. Defendant argues that the plaintiff is an inadequate representative because of deceptive conduct. The court agrees. The plaintiff readily admits his conduct was deceptive. Why is he talking about his conduct being deceptive? I think if you get an undercover police officer on the stand in a prostitution sting, I don't think he focuses on his deceptive conduct. I think he focuses on his investigative technique to investigate, violations of the law. I don't think he focuses on the deceptiveness. Now, the court fully participates in it because, again, I'm sure if that police officer was in this court and he'd been deceptive to arrest a prostitute, I don't think the court would speak about that officer in the same way, but the court feels free of doing that to an ordinary citizen here. But what can you do? Well, you can set up your cases to where if the judge does this to you, it looks very unreasonable and it invites an appeal. And a lot of courts aren't going to want to do that, even if they don't personally like you. And then this is where Johansen versus National Gas and Electric comes back to haunt him. He kind of opened the door to some questionable choices in this lawsuit. Then the court brings up this previous court case and hits him over the head with it. And at the end of the day, most concerning, during his deposition, plaintiff admits he believes that engaging in deception is appropriate behavior for a class representative. So Johansen was he was kind of warned in that first court case. In my opinion, he didn't listen, and that influenced this court case that he brought forward. And then in part 3, it doesn't seem that he's going to learn from the first or the second court case, and the court is really going to hit him over the head with it. So I think that this court case could have gone very differently if he had made some different choices, and we'll see how this plays out in part 3.